Yeah, I now call the December 1st, 2021 meeting of the Board of Monroe County Board of Zoning Appeals to order.
I will call the Mayor Descus-Marchuk.
Here.
Veritas.
Here.
Clemens.
Here.
Sorensen.
Here.
Daly.
Here.
We have all 5 members in a quorum.
Okay. Introduction of evidence.
I request that the following items be introduced as evidence for tonight's meeting. Monroe County Comprehensive Plan, Monroe County Zoning Ordinance as adopted and amended, Monroe County Subdivision Ordinance adopted and amended, the Rules of Procedure of the Board of Zoning Appeals, and the case is docketed and advertised for hearing on tonight's agenda.
Move we approve.
Second.
I will call the roll and approval of introduction of the evidence. Bertie Garitas,
Yes.
Bart Clemens,
Yes.
Vicki Sorensen,
Yes.
Daly,
Yes.
Descus-Marchuk.
Yes.
Evidence is approved by a 5-0 vote.
Move approval of the agenda as advertised and amended.
Second.
There have been no changes to the agenda since it was sent out. This an affirmative vote is a vote to approve the agenda as presented. Bart Clemens,
Yes.
Vicki Sorensen,
Yes.
Daly,
Yes.
Descus-Marchuk,
Yes.
Veritas.
Yes.
The agenda is approved.
Okay.
Set of minutes if you've had a chance to read them. If not, we can continue to the next meeting.
I think Dave wanted.
Dave wants to work on it?
No, I think that it would be advantageous to approve the minutes if people had a chance to read them.
Okay.
Yeah, Larry, we need to approve the minutes for the September meeting so that we can create the record for the Republic appeal.
Can we submit that?
Yeah, the minutes went out for September.
Move approval of the minutes from the September, from both the July 7th, 2021 and the September 1, 2021 meetings.
Second.
Yeah, I'll call the roll and approval of the minutes. Vicki Sorensen,
Yes.
Skip Daly,
Yes.
Descus-Marchuk,
Yes.
Yes.
Bernie?
I didn't hear my name. I'm sorry. Yes.
Bart Clemens. I think
Yes.
you voted already, but we'll just make sure. Okay.
Yes.
The minutes are approved by a 5-0 vote.
Okay, first up, I see we have some administrative business on the electronic attendance policy. What do we need to do with that?
So, thank you, Mary Beth. I'll go ahead and share my screen. So this electronic policy was originally signed back in May. And so one of the stipulations that the Board of Zoning Appeals wanted to place on this meeting, electronic meeting attendance policy, was to review it and make it active for 6 months. So we're placing it back on tonight's agenda in the event that the governor does not extend the public health order and we're to meet in person. We need this to be covered for us to meet hybrid at all, any electronic means. So this is for your consideration again, since there was a stipulation it was active for 6 months. And that doesn't have to be the case moving forward. You can just look at it, approve it or not approve it, and then you can use it even if it's approved. You don't have to use it every month. So that's just what we wanted to bring back to your attention for a vote.
We're voting to extend it.
Yeah. Any questions?
I don't have any.
No questions from the board?
No
I
questions.
do have a question. Can you maneuver? I don't know why I'm only seeing from. I'm not seeing the entire thing. Can you shift it? Oh, okay.
The other way, I think.
No, that's good. For me, at least.
I believe that was in the packet, correct?
Correct, yes.
It
Okay.
was.
Yes. So you just need a motion from us to extend it. How many months is suggested, or to what date, or what do you want us to do?
It's up to you. You can just approve it without any stipulations on the date. That's an option, because as long as the state legislature is active, this is a policy that you can utilize at your discretion. But if you want to put a timeline on it, you may.
Okay. So I hereby move that we extend the electronic attendance policy for public meetings indefinitely.
Second,
Okay, call the roll.
I'll call the roll on the resolution to extend the electronic attendance policy for public meetings indefinitely. A vote in favor is vote to extend the policy. Skip Daly.
I'm gonna abstain.
Okay. Mary Beth Kismarchak,
Yes.
McGarritas,
Oh,
Mark Clemens,
yes.
Vicky Sorensen.
Yes,
The resolution is approved by 3 votes in favor, 1 in the opposition, and 1 abstention.
Okay. First up this evening, we have some old business, and it is case number ADR 21-3. And it is a appeal of the director's interpretation of the pre-existing business uses at 5100 South Victor Pike. And who's going to be telling us about that today?
So we're gonna go ahead and go over the rules of procedure, and then we'll be starting with Mike Carmen, who is the petitioner in this case, the petitioner's representative. Dave, as counsel, do you have anything that you would like to first discuss about the appeal process to the Board of Zoning Appeals?
Nothing in addition to what we discussed last time, which was that this is what they call a de novo decision. So the board stands in the same shoes as the director and can make any decision that the director might have made.
Dave,
That's
one
it.
question. Dave, one question that Jack and I were discussing this morning. We anticipate there'll be, for both those in favor and opposed to the determination, additional evidence tonight.
Mhm.
In your opinion, is the de novo decision based upon the evidence at the time the administrative decision was made?
I think that the board has the option of accepting new evidence and making that determination. So
Okay. Mike, would you like to go ahead and start us off?
Yes. You're gonna take down the rules, or are we going to?
Yep, I can do that.
Well, I don't want those to be a distraction. I'm just ready to get into the appeal if we're ready to proceed. Okay, okay. My name is Mike Carmer, representing P&G Associates, which is the appellant in this matter. On behalf of P&G Associates, we had requested a use determination by Mr. Wilson as the planning director. And that use determination concluded, we believe incorrectly, that truck parking was not a permitted use on the property at 5100 South Victor Pike. Now, last meeting, we got into this, and there are only 3 members present, and there's a 2-1 vote on the motion made, so it's carried over now as under old business. We have, I see, a full board here tonight. The reason that Mr. Wilson asked the attorney, Dave Schilling, about new evidence is because in the time since last meeting, significant new evidence has been disclosed, and it changes everything. And it makes the director's use determination untenable, and it's not founded on proper consideration of evidence. Now, so I'll give you a little bit of background on what this appeal is again, and then we'll get to the new evidence issue, and we can talk about that. P&G Associates bought this property at 5100 South Victor Pike in 2005. The use is ongoing at that time, which they've continued since, was diesel and gasoline fuel sales, a convenience mart, and overnight truck vehicle equipment parking. The overnight truck parking primarily was long-haul truck drivers who were taking break, rest, sleep opportunities, so they parked there. That use had been in place through the time that this property had been developed, starting with Alan Terry, the original developer of this property, who acquired it with his wife Beverly in 1988. And sometime within the next year or two, I think the exact date of starting the business is not clear, but it happened within a year, 2 years at the most. They developed what Alan called a truck stop business. I will tell you, I hesitate using that term, but that's the term that he used. That's the term that's in a statement by Mrs. Terry that's as part of the appeal packet. But I hesitate to use that term only because the zoning ordinance now has a truck stop, truck plaza, or travel plaza definition that is much more extensive on what it is compared to the truck stop that Alan Terry envisioned that has been in place since then. His express intended use was to develop a site on the west side of Bloomington for diesel fuel sales. And in doing that, they put in the pumps, they created the gasoline and diesel fuel cells, had a small building there out of which they actually had a small kitchen in which they ran a little bit of a cafe. They did convenience sales, a lot of, according to the statement of Mrs. Terry, Alan Terry now is deceased, but his widow, Beverly Terry, who worked in the business daily during the time they owned it, workwear suits, sales of boots and other apparel, and some food items and convenience items. And that Alan had constantly and intentionally courted truck drivers to use the area for overnight parking for rest, because it would add to fuel sales and sales from either from their little in-house kitchen or cafe, whatever you want to call it, and other convenience sales. So as part of his business model, they owned and operated the station for several years. And then in 1996, on a contract, they sold it deed over to Sunmart Investments. Actually occurred in 1998, but Sunmart took over the business and continued it. They made some changes, in the words of Bill Thomas, whose statement affidavit is also part of the packet of appeal. But in summary, he talked about making some modifications, clean up, more organized parking, made various changes. They made a concerted effort to eliminate some truck driver parking that frankly applied in the prostitute trade, and got it, and successfully got that stopped. And that's not been a reoccurrence since then. But they operated the station, continuing the same businesses that Mr. Terry had started, which included the truck and equipment parking, and primarily the overnight truck hauler parking, until they sold the property to P&G Associates, the current owner, in 2005. So we have a continuous chain of the ongoing truck parking use on this property since roughly 1999 or 2000. I'm sorry, 1989 or 1990 to date, approximately 30 years. And so the issue has come up recently about the truck parking not being permitted. We disagree with that, and I'm talking about the petitioner. It's been ongoing for 30 plus years. It's been a well-known fact, and no one's ever come forward and say you can't do this until recently. We asked for the formal use determination from the planning director so we could put an end to this dispute on the permitted use or not. And his conclusion and his interpretation of the 1986 zoning ordinance and other documents or other matters was that the truck parking was not permitted. And that's his determination, and we've appealed that. We're asking this board to consider the evidence, and particularly what I'm going to show here in a moment, the more recently discovered evidence, and make a different determination that in fact the truck parking has been formally blessed and approved by the Monroe County Commissioners and by the Monroe County Planning Commission in 1992, and it has continued since then. The zoning on this land is pre-existing business. That zoning carried forward all uses that then existing on the property, and even allows changes of uses subject to a limitation on the intensity of use. There's a standard, it can't be an increased intensity of use, but it carries it forward and continues to allow the truck parking. So you have the statements in the appeal packet from Mrs. Terry that describes the development of this property and by her and her husband. You have the statement of Bill Thomas from Sunmart Investments describing their continuation of the truck parking use during their years of ownership. And then we have coming forward to P&G Associates having continued the use to date. So what is the new evidence that Mr. Wilson was asking Mr. Schilling about, and that I've said changes everything? Jackie, may I do share screen? Which, and I'll try and adjust these to make sure that it's visible. So what is being shown on, I hope you see the full dive by share screen, is zoning compliance needing further action. This is what we would call an enforcement letter. The zoning inspector, you can see it signed by the inspector, Sherry Friley, is identifying zoning violations on this property, 5100. You see it's addressed to Mr. Alan Terry. And you can see what it refers to, off-street parking requirements under Chapter 810 of the then zoning ordinance. This will be the 1986 ordinance. You see the date of this letter is will be in 1991 because it refers to a second letter sent January 11, 1991. It would appear from the tone of this letter that there had been some efforts to contact Mr. Terry and get either him or his attorney to acknowledge some zoning violations with regard to the off-street parking taking place in this property and to make appropriate corrections. Apparently, they were not responsive enough, and you can see in this letter reference that it'll have to be turned over to legal. But what's really important to this is clearly look about in the middle of the text. It talks about this parking area, referring to the off-street parking occurring on 5100 South Victor Pike, is heavily used by both trucks and automobiles. So following this letter and the recommendation that be forwarded to the county attorney filed a lawsuit. This document now being shown is a settlement agreement of the lawsuit that had been filed by the county attorney, who happened to be David Schilling at the time. And I want to direct your attention on this first page of the settlement agreement. You can see where, I hope my cursor is showing up there, I'm circling an area. You see what's called a cause number, 53 CO2 9106 CP. The 9106 tells you that this cause number, this lawsuit, was filed in June of 1991, a few months after the date of that enforcement letter where Ms. Farley said it would be forwarded to legal. And apparently in June of 1991, the county attorney, David Schilling, followed up with filing a lawsuit against Mr. Terry. You can see up here reference to this settlement agreements with Mr. Terry, Monroe County, and the Plan Commission. We go down through the settlement letter. There are a number of provisions in here, but you can see here the issue is discussing paving of driveway and parking areas. And in some detail, it goes through some paving requirements, what it could be allowed left in stone, and some other site development requirements that Mr. Terry would have to implement. Goes on down to an enforcement paragraph. It talks about dismissing the lawsuit. And in this paragraph 7, it discusses enforcement. What if Mr. Terry did not comply with the standards of paving and penetrating oil and other things that were set out in the settlement agreement. And it says right here, if Mr. Terry should thereafter default on this settlement agreement by failing to perform according to its terms, the county and the Plan Commission may file a complaint for specific performance of this agreement and other proper relief, and Terry agrees he will not oppose such complaint. Nowhere in here does it say if there's a default by Mr. Terry, and I'm not saying there ever was, but it never says he forfeits the right to do off-site parking. He forfeits the right to do continued truck parking on this property. Following this settlement agreement, and you can see this was signed by the president of the commissioners, Tim Tilton at the time, BJ Sample was the president of Plan Commission, Mr. Terry, the defendant, and this also ultimately leads to the further action by Mr. Schilling as the county attorney, where he files a motion to dismiss the lawsuit and makes reference specifically to that November 12, 1991 settlement agreement. So we have a clear documentation that Monroe County, through the commissioners, through the Plan Commission, through the zoning inspectors, knew in 1991 and 1992 that truck parking was occurring on this property. The enforcement action was not to stop the truck parking because it was not permitted, but to require some paving and other site improvements. Monroe County, since 1992, has acknowledged that truck parking is a permitted use on this property. The use determination should be struck. I have requested Mr. Wilson to reconsider his use determination in light of this evidence. This just came to light recently. Now, I'm not sure how it came to light. I understand from Mr. Wilson that someone brought it to his attention because for whatever reason, these documents are not in county planning files. I did a public records request and the county complied and provided what they was believed to be everything they had on this property regarding past actions, enforcements, permits, etc. These documents do not appear in there. The lawsuit or the settlement agreement and any of this. Someone brought it apparently to Mr. Wilson's attention. He eventually gave it to Mr. Schilling, and Mr. Schilling provided me copies of it because as he should have, and as he recognized, there was an outstanding request for public records. These should have been included. They weren't known. I don't fault anybody for not including them before, but these should have been provided had they been properly in the Plan Commission files. This would have been part of the packet from the beginning, and the board last month would have seen these same documents. Fortunately, it didn't get a final answer last week or last month. Now we have a further hearing, and these records are available. Mr. Schilling is online. He was the attorney at the time, but there's absolutely no way you can interpret the enforcement letter, the settlement agreement, and the dismissal lawsuit except to acknowledge that truck parking as an off-street issue on this property was permitted. And that's been true since at least 1992, and I was submitted earlier. And that was in light of the 1986 zoning ordinance, which Mr. Wilson insists doesn't allow this. In fact, Monroe County Commissioners and Plan Commission said it does allow it by allowing the truck parking to continue so long as Mr. Terry complied with doing the paving and a couple other site improvements. I would ask this board to, on this appeal, it's not a question of reversing the determination. It's a question of making your own determination as a de novo review of the evidence. But the evidence is that since 1992, it's been recognized by Monroe County that truck parking is permitted on this property. The pre-existing business continued that and would ask you to make that declaration that use determination for uses on this property includes the overnight truck and equipment parking, and would ask you to make that declaration as your action this evening. Just by way of comment, what I have not talked about, other than reference to that the settlement agreement included some of it, site development issues or use standards, whether it's noise, numbers of cars or trucks or other matters. Those issues, I would submit, are not relevant on the consideration of what was a permitted use. Those may be matters to be addressed, and we can do so for appropriate times in an appropriate manner with regard to the ongoing use. If there are matters that are required, whether it's landscaping or tree planting or anything else, those matters can be addressed, but those items, those issues do not go to the issue whether the truck parking was a permitted use. I don't know what their members public logged on. I assume some are going to speak. It should not be a for or against, because this is a factual determination, use determination. It's not a popularity vote up or down. So I'm not going to argue those issues of engine idling and moving to auxiliary packs, and what efforts being made to stop engine idling, to prohibit, what landscaping's been done, what tree planting is yet planned, and those matters, because those aren't really germane to the appeal and your determination. It's the use, permitted or not, is really the only question before you tonight. And I would submit that based on the evidence and the county's own evidence, that these are county documents, that the county commissioners, and planning commission have said, yes, truck parking is permitted use here. We'd ask you to make that determination. Thank you.
Does the board have any questions for Mr. Carmen?
I'll ask a question in reading all the documentation. So this was this new evidence, the dismissal of the motion was in 1991-92. But in 1997, a new ordinance was adopted about parking and the size of a vehicle on the parking. Does that overrule this motion, or can you explain that?
I'll see you.
Okay, thanks.
You may have to consult the county attorney. I'm not sure that you can weigh on that, but for me to answer your question, I want to tell you that it does not. That ordinance you're referring to included the rezoning of this and other properties as pre-existing business. And when you look at the pre-existing business definition and the zoning, it carried forward all commercial and business uses of the property, and the truck parking was an ongoing part of the business use of the property.
And so it doesn't matter that the vehicle has to be under 1 1/2 tons, which a lot of trucks are more than that.
It would certainly matter to the ability to start something new on a different site, and to do something new, that yes, those standards would apply to that. This is essentially grandfathered. If you want to look at it that way, it's not the right term, but it's what we all use. But it was a use that was existing and permitted, and the pre-existing business zoning that the county put on this property carried that forward as a continuing permitted use.
Okay, thank you.
Just to clarify, was your question directed towards county legal? You want Dave to weigh in on that question if he has any differing opinions?
That would be good.
Okay.
Heck, I apologize if you could repeat that question, Vicki.
Sure. I was just wanting to know if the ordinance adopted and effective on January the 8th, 1997 regarding parking overweighed the motion was dismissed in 1991-92 on everything.
Well, my understanding of the pre-existing business zoning designation was that it was intended to allow uses that were in existence to continue to exist as they were. And that would make sense that parking continue if parking were regarded as an accessory use to the primary uses of that property as a gas station and a grocery store. Yeah.
Okay. Any further questions for Dave or Mr. Carmen?
I have a question for Dave, and it has to do with the changing definition of parking, and what possible parameters could have changed over the last 30-year time period with regard to parking. It's one thing to park a truck and go into a store, get gas, take a shower, etc. If the shower facilities are available, or get a meal. It's quite another thing to leave a truck running overnight. Is there, how is parking defined, and how have the parking definitions changed, especially as they pertain to trucks? And are these things relevant to our discussion today, Dave?
Well, as far as how they're defined today, I don't believe that those are relevant to your determination as to whether this use existed and was encompassed in the pre-existing or business district scope. So, I guess the question, you'd have to look at the 19 what I guess it's basically an 86 ordinance for the rules that would apply to this decision. So change any definitions relating to parking or regulations relating to parking in the 1996-97 ordinance would not apply to this consideration.
Skip, do you have a question?
I do. Is it appropriate to ask Mr. Schilling a question at this point?
I believe that would be appropriate.
All right. Well, thank you. Mr. Schilling, it looks as if you were the signer of this dismissal back in 1991. Is that correct?
That is correct.
All right. What were you thinking in 1990? I know that's, I know you've had a couple of meals since then, but what was your thought in signing this? Do you agree that at the time that you acknowledged that this was a present in existing use of the building?
Well, Skip, what I can remember, and I didn't even remember filing the lawsuit, but I did remember that I thought that we had resolved the issues. And so looking at the lawsuit, it reminds me that we were trying to address complaints about dust caused by the trucks moving across the lot. And that's why the paving and the dust oil was part of the remedy, because that was the complaint that we were getting from neighbors about the dust.
Okay. Well, you dismissed it, and there was no additional, for decades now, no additional problems, right?
I don't know. I have not received any complaints, but I typically don't receive complaints. That would be staff.
Right. Okay, that answers my question. Thank you.
Okay. Any further questions for Mr. Carmen or Dave?
I do have another question, Mary Beth, to Dave. Dave, does it make any difference in whether the property is considered a gas station, convenience store, or a truck stop plaza?
Well, there wasn't a truck stop plaza definition back in the old ordinance. So that wouldn't have been a consideration when we dealt with this in the 90s.
Okay, thank you.
Yeah. Any further questions for Mr. Carmen or Dave?
The way I have a question.
Okay.
The way that I am seeing this is we need to determine whether or not this was a pre-existing use of the land prior to the lawsuit and the dismissal. And that's really the only business right now that we're determining, not what if the truck stop definition included this or that. It's what the county allowed and whether or not this has been a continuous use of the property for since its inception. Is that correct? Mr. Schilling?
The pre-existing business zone was designed to allow existing businesses to continue as they existed.
All right. Pretty clear cut. Thanks.
Everybody's questions been answered? Okay.
I have a question. You know, I mean, there have been incremental changes at this business. It hasn't really just continued as it was. There have been incremental changes with incremental growth of the parking operations into overnight parking operations. So I don't understand, you know, the argument for continuity. Mr. Schilling, could you address that?
Well, I'm not sure about the change in the nature of the parking. There has been expansion of the parking areas and so forth, which will need to be addressed through permits or however the staff decides to direct us to do that. So there are, as you note, incremental physical changes out there, but I'm not sure about the changes in the nature of the parking.
Okay, any further questions for Mr. Carmen or Mr. Schilling from the board? Bernie? You're muted.
Yeah, thank you. I don't know if this is a question for anybody, but kind of boiling this down the way I'm looking at it, it kind of springboards off what Skip was saying. You know, it's to me, it's not a question of compliance, whether the geometry, whether the incremental changes, whether the adaptations that have happened over the years are relevant to any ordinance, other than the fact that whether I believe or we believe as a board that this has been a continuous use as a overnight truck stop or truck parking area for the last X number of years, as presented in the evidence that the petitioner's representative has provided. And those are the questions that I'm asking. Things change all the time. You have I-69, you've got houses that are built, houses that are torn down in the area. There's all kinds of changes about, but my perspective is whether or not it has been used for this purpose fundamentally. And that's the set of lenses that I think I'm looking through to try to understand what our work is here tonight. So,
Okay, thank you, Bernie. I have a question for staff as we throw this open to the public for their comments, either for or against this petition. Can we limit the speaking time to, say, 2 minutes?
I guess I would request staff have a chance to respond to Mr. Carmen's presentation.
Okay. Well, yes, I'm sorry. Staff, would you like to respond to Mr. Carmen's presentation?
I certainly would. First of all, if we go to the lawsuit materials, if you go to the inspector's report, the fact that the inspector called it a truck stop does not make it a legal truck stop. If that was the case, we were in real trouble, because it's not uncommon for an inspector to call something a junkyard, an event center, a repair garage, in referring to a use on the site. Secondly, the only use that the use determination dealt with was overnight long-term parking of trucks. Under the gasoline definition in my use determination, if we can pull that up, it's on. This was a limited business. Mr. Waterford, who owned the property prior to the Terry's, came into and had the property rezoned from agricultural. He asked for general business. The commissioners zoned it limited business. These are the uses that on the screen that are permitted by limited business. As you can see, there's not a convenience store. There's not a truck stop. However, there is gasoline service station, and there is parking area, public or employee. And if you go down to the definitions for these uses, this is very important. The ordinance says here, ordinance 8619, which is the 86 ordinance, it was in effect until 1980 or 1997. It says, except as provided, no building or premises shall be used for any purpose other than permitted in the zoning district in which the building or business is located. No land or lot area shall be used for diminished so that the yards or open spaces are smaller than prescribed. Only uses permitted in the limited business district could have been established legally on the site. So the question, that was the question for the use determination, is what uses were permitted that were established on the site. If you look at gasoline service station, it says a retail business supplying automotive fuels and lubricants directed to customer vehicles. The term vehicle is broader than automobile, and in my interpretation, that includes semi-trucks. So I don't think there's any question that the site can be used as a fueling station for semi-trucks, okay? That's not what this is about. A fueling station for semi-trucks. And I also would note that under our current definition of truck stop, overnight parking is all optional. And if you go back to the common definition of a truck stop, it doesn't necessarily include overnight parking. It's not a given. Typically, it's a place where truckers can fuel up, get a cheap meal, maybe buy snacks and so on, and move on. It may or may not include overnight parking. We did not have a use in our ordinance until we amended the ordinance in 2014 to establish truck stop travel plaza as a special, as a conditional use. Then we even have a definition of truck stop. So the idea that you're calling that they thought they were having a truck stop is not inconsistent with the use of a gasoline service station. You know, because the use does not necessarily include overnight parking. I want to focus in on the definition of parking area public, because this is the key to my decision that overnight parking was not allowed. Again, the ordinance only allows uses that are defined and set forth in the ordinance. Parking area public, area other than a street used for temporary parking of more than 4 automobiles and available for public use, whether free, for compensation, or an accommodation for clients or customers. It specifically refers to automobiles. And you can say, well, that has to be a mistake, you know, because we have pickup trucks, we have utility vehicles. It was a mistake. They amended the ordinance, as Vicki Sorensen referenced in 1997, to add other vehicles such as pickup trucks, utility vehicles, and trucks less than 1.5 tons. Okay, but until that ordinance amended was technically no, there was no parking in the public parking area for anything other than automobiles. Okay, that's what the ordinance said. You know, you can say, well, that's a mistake, that shouldn't have been that way, but I don't have the power in making a use determination to amend the ordinance or rearrange the clear meaning of the ordinance. And I would submit that you do not have that power too. In regard to the pre-existing business, Mr. Carmen argues that any use on site automatically, magically became a permitted pre-existing business use when the ordinance was passed in January 1997. Any use whatsoever, whether it was permitted by the ordinance or not, if it was on site, it was permitted. That makes no sense at all. It's pre-existing business use. If you want to determine what pre-existing business uses would be allowed on this site, you go to the permitted pre-existing business uses, which were gasoline station and public parking for automobiles. Those are the pre-existing business uses. Just the fact that they intended to do a truck stop and that trucks may have parked there does not mean that's a pre-existing business use. As I said in my initial letter, it shows only that they were not in compliance with the requirements for parking. But think about it. If somebody has a car for sale on their parking lot at the time the ordinance went into effect, they have a pre-existing business use for an auto sales lot. Or if somebody in the back, I mean, if there's a pile of junk cars behind a building, they have an automobile scrapyard, it makes no sense at all. And if you look at if you look at the pre-existing business definition, the intent is to allow zoning uses that were in existence that were no longer supported by the comprehensive plan. And we have a lot of those. Maze Greenhouse, there's a veterinarian clinic down on Old 37. That's a pre-existing business use. They were in existence. The comprehensive plan says, we really don't think these are areas where businesses should occur, but we want to allow them to continue. We don't want to take the value of the property from the owner. So we want to give them the power to sell their property and allow somebody to convert it to a business of equal or lower intensity. How do you convert it to one of equal or lower intensity unless it's one of the pre-existing business uses that was in the table before? So you could say, okay, yeah, this was a use. Gasoline station is this use. Therefore, you can convert it to another legally provided business use, and then and change the use to that. It makes absolutely no sense to say that whatever activity, whether or not it was permitted by the ordinance or not, is grandfathered or somehow carried over into the pre-existing business ordinance. It makes no sense. It didn't magically switch from an illegal use on the day to a legal use when the ordinance was passed. And if you look clearly at that definition, it's to accommodate commercial and business service uses that were in operation prior to the adoption of the zoning, of this zoning ordinance. Again, a illegal use is not a business service use that was legally being undertaken under the ordinance. It just, the whole idea falls apart. Finally, I want to talk about the lawsuit. The lawsuit clearly, if you look at the language of the lawsuit, we don't have the complaint. Absolutely, we don't have the complaint. There's nothing in that settlement agreement that says, okay, yeah, we agree the trucks or the owners can continue parking semi-trucks on the lot. It addresses questions of design standards under Chapter 810 in the zoning ordinance. Chapter 810 requires paving of heavily traveled driveways and parking areas. That does not say that, well, oh, that means you have overnight parking for semi-trucks. It doesn't say that. It says the development standards for parking lots requires this lot to be paved and the driveways to be paved. It requires a buffer yard with plantings. And there's nothing in that. If you read the settlement agreement, there's nothing at all that even mentions truck parking. It says parking areas. It says paving of driveway. It doesn't say anything about, oh, okay, and by the way, your overnight parking use is okay, and we're not going to enforce against you. I don't know why. I mean, the other thing in doing a use determination, I want to briefly go through my methodology of use determination. I've done almost 100 this year, okay? They're not exhaustive, obviously. I don't have the ability to go check all the court records, do title searches, and so on. Here's what I do. I look at the aerial photographs that have a history of the project. I go through the zoning ordinance to see what zoning ordinance was in effect at the time the business began. I look through our records because the one concern I have is that I think if we'd approved a site plan, if they'd filed a site plan for this, if they had filed an improvement location permit application for their gasoline service station, and we approved it, and on that application, it said overnight parking of trucks, I think at that point, we might be stopped from challenging it. They did not, or at least there's no records. We have no records from that time period. other than the fact that this is what the ordinance says. And again, I don't have the power to change the terms of the ordinance. When it says automobile parking only, it means what it says. And when it says parking of trucks less than 1.5 tons, it means what it says. That is why we established a conditional use for truck stops, because we had no provision for overnight parking of trucks or for even short-term parking of trucks. If you look around the county, there's no gas station that has parking for trucks. You know, this is the only one that has been allowing parking for trucks. And again, my determination does not preclude them from continuing sales of diesel fuel and gasoline to semi-trucks. It's the long-term overnight parking of semi-trucks, of utility service vehicles, of contractors' vehicles, of milk trucks, and so on, that's not allowed under the ordinance or the pre-existing business ordinance. You know, again, I ask you to look at the ordinance. I ask you to read my use determination, because you know, I try to be very careful about these. I want to make the right decision, but again, my obligation is to follow the ordinance. And if the strict language of the ordinance precludes a use or allows a use, I'm obligated to follow it. I can't read in and say, well, you know, a semi truck is kind of similar to an automobile, so we ought to be okay with that. Doesn't say that. And again, you know, Mike's an advocate for his client. I'm an advocate for the zoning ordinance. This zone was zoned limited business. It was zoned pre-existing business because it was adjacent to residential neighborhoods. And if you look at the intent of both limited business and pre-existing business, it was to avoid high intensity, high traffic uses next to this area. And the clear intent of the ordinance is not to allow industrial uses or high traffic, high intensity uses in this area. And that was the basis of my use determination. I will point one other fact, since we are allowing new evidence, is this is not the first use determination I made on this site. In 2020, there was a request for use determination. And can we pull up that? Okay, this was by the owners, and they called it a convenient smart at that time, not a truck stop, a convenient smart truck stop. And again, this was based upon the current ordinance, not the old ordinance. But again, I have no ability either under the 86 ordinance or the 97 ordinance. In the limited business zone or the pre-existing business designation, overnight truck parking or parking of heavy trucks has never been permitted. That's all I have right now. If you have any questions, I'd be glad to answer.
Does the board have any questions for Larry?
I have a quick question for you. This overnight parking seems to have been happening for over 30 years. You reside in the county. Why is this the first time, or the first time in 2020 apparently, that this has been brought to light if it was not an accepted use?
I'll be glad to answer that. I think, first of all, it's of a night. We don't have night zoning inspectors. For a lot of uses, they're based on complaints. They're not based upon our ability to go out and check every use. You would not want a planning department that was driving around at night and kicking in doors to see what was going on. And we don't do that. The other thing is the parking. If you look at the aerial photographs, which are in the packet, it's intermittent. You know, it was heavy at some point. It's only gotten really heavy since I-69 went through, because there was a limited demand for overnight parking. When I-69 was built, the state and the federal government chose not to put in any rest area between here and Evansville, which has created demand for a place where truckers can park. That's why you see trucks parked in the sides of overpasses, you know, on off roads, anywhere they can find a place. There's an adequate parking. And that's one of the reasons we put in the provision to allow for a truck stop as a conditional use, so that it could be addressed with the coming of I-69. But in regard to enforcement, we have limited resources. And basically, to be real frank with you, we address those issues where we get complaints, because we don't have the ability to go out and monitor. There's no way we would know whether trucks are parking there overnight unless I send somebody out to stake out this truck stop. And again, we don't have that capacity to do that. So we rely upon inspection reports, complaints for most of our inspections. And quite frankly, I think Dave can address this issue. The Indiana case law is absolutely clear that a municipality is not a stop from enforcing its zoning ordinance for failure to enforce it in the past. The courts have realized that government has limited resources and that they have to set priorities, and that as a part of setting those priorities, they may have to let enforcement go. You know, if we have a site with 1 or 2 semi trucks and nobody's complaining, we don't have the capacity to like go after them and say, hey, just like we don't have the capacity to clean up every residential yard that has a junk car in it, or every complaint somebody has in regard to their next door neighbor. We have to carefully choose and determine what enforcement actions we take. That's why the courts have said that there is a leeway for municipalities. They're not a stop from enforcing the ordinance just because they have not enforced it in the past. There is an estoppel principle that I mentioned earlier, that if the plan commission or if the planning department or the BZA or the plan commission had approved overnight parking in some manner, then we would be a stop from saying it's not allowed. Now, that's not the same thing as a estoppel based on lack of enforcement. They're two different things. And the only thing that's been shown here is that we didn't stop them from doing their illegal use.
Does that answer your question, Skip?
I appreciate Larry's response. Yes, we'll leave it at that.
Okay, Bernie, you have your hand up.
Yeah, Larry, that was very insightful. I mean, as far as how you handled your use determination. Jackie, could you put on the screen Sherry's report back to the commissioners back in, I think it was 92 or 1990. Just indulge me just a second, if you would. Okay, thanks.
Okay. Any further questions, Bernie? No.
No, not right now.
Okay. Any more questions for Larry? Okay. Now, I have a question for staff. Just getting ready to ask prematurely. It is now time for us to have the public speak on behalf or against the petition. And I was wondering if we can limit those comments to 2 minutes. Is that something we need to vote on?
Yeah, you can do that, Mary Beth. If you go ahead and vote on it, you're allowed to place time limits.
And I will note that Mr. Carmen will be entitled to rebuttal at some point.
Yes, Mr. Carmen will be entitled to rebuttal without a time limit. This is just statements from the public. I know we had a lot last time. Margaret, did you want to make that motion?
Bernie has his hand up.
Oh, Bernie, go ahead.
Yeah, I want to make sure that we understand what the public input is important. I'm not trying to discount that at all, one way or the other, but I want to make sure that the context at which the public comment has to do with is the question of whether or not, maybe not whether or not I like what has been going on there, or that I do like what's going on there.
Yes, that is something for
Is that
the public to keep in mind.
Is that an appropriate question to ask? I'm not trying to lead my fellow board members, but I just want to make sure that we understand and that we all understand what we're discussing.
Are you asking staff if you can limit as a board the specific content of comments by the public?
No, I don't want to limit the public. I just want the public to understand, just as everybody else, that we're discussing whether or not a use determination and what historically has been going on there maybe is relevant. Not that, I don't want trucks there. I do want trucks there. I think that that's important to understand. That's all I've got to say, because I don't want to come across as telling the public what to say, but there's a very direct context and target that we're talking about this evening, and so that's it.
All right. Okay, I'll go ahead and make the motion that we limit the public comments to 2 minutes per person.
I second that.
Okay. I call roll, Larry.
And make it specific. Is the motion specific to this case in general, or are you saying for the rest of the evening?
As well.
To this case in general.
To this case in particular?
Or, yeah, this case in particular, sorry.
Okay.
Okay, I will take the roll. Vote is on to limit public comments on ADR-20-3 to 3 minutes.
2 minutes.
2 minutes. Okay. All those a vote in favor is vote to limit it to 2 minutes. Mary Beth Kasmarchak,
Yes.
Garitas,
Yes.
Barbara Clemens,
Yes.
Sorensen,
Yes.
Daly.
No.
The vote is 4-1 to limit discussion to 2 minutes.
Bernie, I see your hand is up. Okay, Bernie's hand's down. Now, are there any members of the public that are here to speak on behalf of this petition? Can I give you guys some time? I'm not seeing any hands or hearing anybody. Anyone here that would like to speak on behalf of this petition?
I see a hand raised, Mary Beth.
Okay. I'm not seeing it.
I think it just was put down. I don't know if, Vanessa, were you wanting to speak in favor or opposition?
I definitely in favor, but I guess I have a clarification question that I didn't hear addressed. But if it was addressed, I apologize in advance. My question is, well, it's twofold. Is that when the ordinances were developed back in the 80s, whenever this lawsuit was
Excuse me,
filed.
Vanessa, this really isn't a question time for the public. It's more of a if you would like to speak on behalf of it or if you would like to speak against it.
Then I don't have anything to add because I have clarification questions in order to be able to articulate my, support of it.
Okay, thank you. Tommy Ballas, would you like to speak on behalf of this petition? Like to unmute yourself? Tommy, your hand is up.
Oops,
Oh, hi, Tommy.
sorry. Sorry, I figured
All
it
right,
out.
Tommy, do you swear to tell the truth and nothing but the truth?
Yes, ma'am.
All right, you can proceed.
Hi, I'm
State
here
your
to
name.
speak on behalf of the Sunoco gas station. My name is Tommy Blaze. I grew up across the street. My wife's family previously owned the gas station. When they were operating the truck stop, they let trucks park there overnight, and they never really had any problems. For the 20 years I lived in the area, I never really had any problems with any noise from overnight parking. And I know Rosie and Pilo are the owners, the type of people to just want to make sure truckers have a safe place to get a rest and a good meal. And since the station has stopped overnight parking, I noticed a lot of truckers have resorted to parking on the sides of large interstates. And that's obviously not safe. I don't think it's fair that we as people really enjoy how fast we can get things now, but we don't give the truckers the decency of safe and reasonable parking. That's all I really have to say.
Okay, thank you, Mr. Blaze.
Thank you for your time.
Christine Wolf?
Yes, thank you. I'm here in support.
Do you swear to tell the truth and nothing but the truth?
Yes, I do.
You state your name.
Christine Wolf. I'm here to speak on in favor of the continued use of the Shell station as it has historically been used. I am looking at it right now from my living room window. I live in close proximity to this business. I lived in this house on Victor Pike since 2013. In all the years that I've lived here, this place has been used for overnight parking. In this close proximity with it almost directly across the street, have never had any problem with noise, odor, pollution, any of the things that I've heard alleged. The thing that has changed is not, in my opinion, the development of I-69. It is the fact that we have another new neighbor who lives across the street. And I think this has to do with property values. I don't think that it has to do with the condition of the Shell station or anything that is happening there. That is the change that I have noticed. A new neighbor, and all of a sudden that there are complaints. And as far as the comment about this not being intended to be an industrial area, we actually live adjacent to two industrial parks, one across 37 and then one adjacent kind of down the road from the Shell station. We also live in close proximity to the county's water treatment facility. So while we do have, residential properties here, with some, spacious yards, we do live in close proximity to industrial usage. And it doesn't make sense to me that we would have it disallowed on a particular corner and then allowed in every single adjacent area, just about. And then finally, this distinction about 1.5 ton trucks doesn't make any sense to me either. Standard automobiles these days already weigh more than that. Pickup trucks weigh more than that. My SUV probably weighs more than that. And if I can't park there in my
Thank
family
you, Christine.
car, then
Thank
that's
you.
news to me. Thank you.
All right, Scott and Natalie Blaze, or Scott or Natalie, which one?
Hi, thank you. I want to say up front.
Is this Natalie Blaze?
This is Natalie Blaze, and I do attest that I'm going to say everything truthfully. And if you need me to do something specific,
Do you swear to tell the truth and nothing but the truth?
I do.
All right, thank you, Natalie.
Okay, I would like to mention that the prior speaker not being allowed to finish her comment, I think is rather grotesque. This is obviously a subject that is highly debated, and for you to not give someone the final word to say what they need to say is highly inappropriate. I'm going to go back as far as the 9192 listed requirements, not eliminated usage. You are determining what you are determining without actually listening or learning from the prior usages. The parking definition as far as short-term versus overterm, Schilling signed off on this. This was an argument that was prior. I can't. So we're looking at pre-existing use of the land. Margaret commented on incremental changes and just stated a blank statement, yet did not comment on the actual change or the proof of those changes. Some overhead footage does not determine whether that is actually a change. I would really like to hear Margaret's concerns over what those changes were. Bernie talked about compliance relevant to current usage, and I think that's spot on. We have unknown truckers, according to the board that we're looking at. I would like to know how you know they're unknown. Where did they come from? Where have they traveled from? What are they serving? You're making blanket statements that is going to affect our local community, and yet you're not taking into consideration the fact that there is intricate details as to what those folks are all about. I'm going to run out of time. I have 7 seconds. There is so much more that needs to be said. And I resent the fact that you were allowing us only 2 minutes to express our concerns, especially since you had way more than that.
Okay, thank you, Natalie. That's for the public section. The actual petitioner had plenty of time to present in unlimited time.
So if the petitioner had that time, how can you eliminate or minimize the fact that the folks that are surrounded by this, that are suffering and dealing with this, are only limited to 2 minutes?
Natalie, so part of the rules of procedure of the BZA is that there's authority of the board to limit the public comment for a case. So they have voted to limit it to 2 minutes, and we apologize if you feel like you don't have enough time, but that was the
I agree,
vote.
Jessica. So what I would like to know is, what are the ramifications, and what can we as the public who has the position to offer more, how can we be given that concession? I think 2 minutes is completely unrealistic with something that is highly decisive. How can we as the public dispute your 2 minute requirement? I want to do that now on the record.
That's something legal can answer.
Okay, Schilling, what's the answer?
The answer is the board has limited the public input at this time to 2 minutes. If the board decides to take additional input, they can do so if they have time. But they have made a decision, and that should be respected.
Well, I respect the board. I'm disrespecting the 2 minutes. So I would like to know what we can do as the public to get our point across, because I don't think you were fully.
We need to move on. I apologize.
Okay. Thank you. Tina Rogers, are you there?
I'm here.
Tina, do you swear to tell the truth and nothing but the truth?
I do.
Please state your name.
Tina Rogers.
Okay, thank you, Tina. Please continue.
Hi, I've been a resident of the area since 1987. The trucks are a use that have always been in place. The individuals who went ahead of you and made the decisions that you're going to try and make another decision about knew that those trucks were there. That is why it was called a truck stop in the documentation. Also, it has been legally addressed. Mr. Schilling signed off, dismissed it.
Thank you.
I don't understand how your board now sees it okay to say, okay, the judge, it was wrong. They made the wrong decision. We've got to make a better decision. I also agree that with Ms. Blaze says, it is actually quite inappropriate when you guys do not live in this area. It is our part of the community. And we are the ones who need to be able to be heard. Not hearing the people who are the ones who this community is here for, who you're supposed to be representing, you got to do better. Thank you.
Thank you.
Thank you, Ms. Rogers. Okay, is there anyone else here that would like to speak on behalf of this petition?
I would like to accept the last minute that she did not use. Is that not allowed? I think
Mary Beth,
Congress does that all the time. They
I've got a point
pass
that I
back
want to make
minutes.
for the public.
Pardon me, Bernie?
I've got a point that I want to make for the public if I can.
Yes, please.
Okay, we've got minutes, we've got a report, we've got things that are published in advance. The last speaker, Ms. Rogers, did a very nice job concisely bringing her points across. I think that she was prepared. 2 minutes, I think, is, if you've gone through and you understand the data and you've researched, you have a point to make, maybe take notes beforehand or something. I think that the 2 minutes is something the board's determined, because we can listen to what people have to say in a very concise and executed manner. And I think that we just need to keep moving, and the 2 minutes is the 2 minutes. That's all.
Oh, I was not prepared. Thank you, Bernie.
Okay. Is there anyone else here that would like to speak on behalf of this petition?
I would. Natalie Blaze.
Natalie, I believe you already had your 2 minutes. Thank you.
Thank you.
Okay. Is there anyone here that, besides Natalie, that would like to speak on behalf of this petition? Okay.
I don't think Mary Beth.
You're not seeing anybody? Okay. Is there anyone here that would like to speak against this petition? Jeff Morris. Jeff, do you swear to tell the truth and nothing but the truth?
I do.
Please state your name.
My name is Jeff Morris.
Okay, thank you. You may continue.
My family and I live across the street from the gas station, and I spoke last month about some of my concerns. So I wanted to speak up again this month since my concerns remain unchanged. I wanted to mention a couple of points from the lawsuit settlement that was shown earlier, as there are specific requirements outlined to protect the neighbors. A couple of examples are, and I'm paraphrasing, evergreens were supposed to be planted every 12 feet along the sides of the property adjacent to neighbors. Nearly all of these have been cut down in recent years. The entire parking lot was supposed to be paved within a couple of years of the settlement, and the parking lot has been expanded multiple times since then, and the parking areas are now primarily gravel. Also, it clearly states in the settlement that all requirements listed are passed on to succeeding owners. As was mentioned, this site is zoned pre-existing business, and under the pre-existing business designation set in the 90s, the intensity of the site may not increase. In looking at satellite images in the packet and looking over the requirements in the settlement, it's undeniable that the parking area and intensity has greatly increased since the 90s. In fact, just last week, I looked out my front door and noticed another couple of dump truck loads of fill had been dumped on the northern edge of the property. This is the exact same way the parking lot expansion on the eastern part of the property started back in 2019. A few dump truck loads of fill here and there, and eventually there's another parking lot expansion that's been completed. If this intensity increase had followed the proper channels, adjacent property owners would have had a chance to speak up. However, when it's completed slowly over time behind the scenes, it bypasses the process that was designed to be inclusive and transparent to everyone impacted. As I've said before, I support the permitted use of the gas station. However, the slow changes over time that don't meet the county standards should not be permitted. Approving truck parking at this site only rewards the behavior of this slow, under the radar approach to growth. This is not respectful to the neighborhood and is not respectful to any other Monroe County resident or business owner who abides by the rules. Thank you.
Thank you, Mr. Morris. Is there anyone else here that would like to speak against this petition?
There it is, right there. Hi, yes, my name is Patty Bush. I would like to speak against the petition.
Patty, do you swear to tell the truth and nothing but the truth?
Yes, I do.
Okay, thank you. You may proceed, Patty.
I have 3 short points that I'd like to make. And the first is my concern personally is for the health and welfare of my family. Diesel particulate matter is a carcinogenic, and I work outside every day, several hours a day. And although I don't smell the diesel smell every day, I have smelled it very heavily. And when it is sitting in the air, when the air isn't moving, when we have a cold front come through and the air is heavy, it makes me ill. I don't feel I should have to smell that. My second point is trucks can park at Walmart and they can also park at Sam's. I checked with the headquarters of Walmart and I checked with the Sam's manager. At Sam's, they can park for 24 hours at a time. So this parking along the side of the road, at least in this vicinity, is unnecessary. My third and last point is someone was curious about the weight of semis. My brother's a truck driver, a semi-truck driver. So this poundage, I learned from him. A semi-trailer and tractor weigh approximately 26,000 pounds loaded. They can weigh up to 80,000 pounds. That's a lot of weight on Victor Pike. Thank you, I'm finished.
Thank you, Mrs. Bush. Is there anyone else here that would like to speak against this petition? Are you seeing any?
I do not see anyone. Mary Beth.
There's no one else here that would like to speak against this petition. Mr. Carmen, would you like to rebut?
Yes, thank you. I'll do my best to be respectful of your time and just try to make specific points and not be redundant with things said earlier, but there have been some statements made by Mr. Wilson and actually a couple others that really compel response. And so with regard to a couple of the last comments, I tried my best. I know there are people on both sides of this issue who feel strongly about it for whatever reason, for and against, and they had things they wanted to say. But I would submit that most of what you've heard are not germane to the issue before you, which is a determination of a zoning issue of a permitted use, not performance issues. And the reason that's important because frankly, Mr. Morris either has misread and therefore I would assume misread because he's misstated the terms of that settlement agreement with regard to paving. But that's really not the issue before you tonight. So it shouldn't be necessary to analyze his interpretation and actually what it does say. But certainly Mr. Wilson's interpretation of some of the ordinance language is pertinent. And I don't know if you could put up page 23 of the packet. I believe that was the page that had the definition of pre-existing business on it. Jackie, if you're able to do that. No, I can read it to you, but I thought it was displayed early and I thought I noticed that it was appearing to be page 23 of the packet. It was the definition of pre-existing business district out of the zoning ordinance. Okay, now let me go on. This is what there we go. So Mr. Wilson repeatedly kept misreading this. It does not say in any place in this definition, existing lawful businesses. Now, I'm not trying to be funny with that. I'm not trying to be coy about it. It says intended to accommodate commercial business services uses that were in operation prior to the adoption of this zoning ordinance. It could have said lawfully in existence, but it didn't. There was a decision made by the Planning Commission, ultimately by the commissioners when they approved the zoning ordinance, this definition, that they were not going to analyze the existing business uses in operation in 1996. They're just going to do a blanket, you can continue, period. And that's what they did. And that's what this definition does. Now, Mr. Wilson wants to read into it. He faults me for what I'm saying, and that it does say truck stop here, it doesn't say truck there, it doesn't say truck parking here, and yet he reads this definition only by adding words to it that are not there, that were never intended to be there. If you go to the settlement agreement, it might be easier if I on share screen, I can pull that up quicker. If Jackie will, yeah, thank you. I need to take this one down, the settlement agreement. Go down to, scrolling down to paragraph number 2, a little bit further. It's going to be, okay, all right, sorry, I've got more paragraphs too. I'm sorry, that's phase 2, paragraph B, the next page. That's scroll on down to paragraph B. You're on A, thank you. Right there, paragraph 2, B and C, look at phase 2 and 3. So much was made earlier about vehicle parking versus truck parking, what the ordinance defined, whether it was a mistake and it had to be amended some years later. Look at this language that the county commissioners and plan commission approved in 1992. Motorized vehicle traffic or parking. It doesn't say sedan parking, car parking, truck parking. It used an all-encompassing term, motorized vehicle traffic and parking to be paved. This language incorporated truck parking. They chose not to limit it to referencing car parking or sedan parking or basic homeowner automobile parking. It's a term that you would not use in ordinary parlance. Motorized vehicle traffic, that's a specific language and appears twice. Phase 2, phase 3, they did it again. Used for motorized vehicle traffic or parking. If you go back to the enforcement letter where that starts all this, Jackie, that was the first page you showed. If you can scroll back up, thank you. There, look at what this is. It says non-compliance with Chapter 10 off-street parking. It goes on to talk about heavy use by truck. It goes on to talk about wheel stops. You do not use wheel stops for trucks that are parking to run in and buy a pack of cigarettes in the year, not now, perhaps, or Coke or candy bar or some other convenience item. You don't use wheel stops for that parking. You use wheel stops for longer term parking, whether it's overnight, 24 hours, or whatever it's going to be. This ordinance led to an enforcement action filed by the county current attorney, ultimately reaching a settlement agreement that all dealt with the off-site truck parking as well as other parking, but it certainly incorporated the off-site truck parking. Mr. Wilson's current interpretation of the 1986 zoning ordinance fails in the face of what the powers that be, the appropriate government officials at the time, how they interpret that ordinance. They've clearly interpreted to find that the truck parking as an off-site street parking was permitted. Otherwise, you wouldn't have an enforcement action about the design standards of paving it or not. They made a finding in that time that, and Mr. Terry relied upon that, Sunmart Investments relied upon that when they bought an existing business, had the ongoing truck parking. P&G Associates relied on the county's actions from 1992 because they bought a business and continued the already existing truck parking. 30 years of that creates a estoppel. I'm not going to debate legal issues with you. That's why we have lawsuits. We can debate the law there if that becomes necessary. But it's very clear that the county said in 1992, off-site truck parking is permitted here, but you have to do paving. And you cannot now change that. 30 years of time, changes of ownership relies upon that. You cannot now reinterpret an ordinance that no longer exists. That the county has spoken. They've spoken in the dismissal lawsuit that incorporated this settlement agreement that was based on this enforcement letter that was dealing with off-site truck parking. And based on that, the use determination by Mr. Wilson cannot stand. And the only possible determination that you can make, I believe, under the evidence is that the county has already spoken and said that off-street truck parking is permitted at 5100 South Victor Pike. I would ask you to formalize that again and restate it. Thank you.
Okay. So I'm gonna flash those rules of procedure back up there for us. See where we're at. Now, does the board have any questions for Mr. Carmen? Okay. I Not seeing any questions from the board about Mr. Carmen. Are we ready for motion?
I can make a motion, Mary Beth.
Well, okay, here it says which time staff recommendations can be made. Do we need to do that now? Or
I think this is just referring to like what the staff recommends in the packet as far as a motion.
okay. The recommended motion by staff was to affirm the administrator's determination. Is that correct? Bernie,
Did you hear me? I didn't know if my mute.
Are you ready to make a motion, Bernie?
I can make a motion, yes.
Okay.
Okay. In the matter of petition ADR-21-3, appeal of director's interpretation of pre-existing business uses at 5100 South Victor Pike, owners P&G Associates LLC. I move that the Monroe County Board of Zoning Appeals reverse the director's interpretation of the site as a pre-existing business located at 5100 South Victor Pike, and that the use of truck parking and overnight truck parking has been a continual use for a period of 30 years or more, based on the evidence presented and the facts found in the staff report.
I'm not hearing a second for the motion.
I second the motion.
Okay, the motion has been made and seconded. Larry?
Okay, the motion is on petition ADR-21-3, appeal of director's interpretation of pre-existing business use for the property located at 5100 South Victor Pike. The motion is to set aside the determination of the planning director and find that the use of overnight parking as a pre-existing business use on the site that has continued for 30 years and is a pre-existing business use of the site. Okay, I will call the roll. The vote in favor is a vote to overturn the determination and find that the overnight parking is a pre-existing business use. Mary Beth Smarchek?
No.
Bernie Garitas?
Yes.
Margaret Clemens?
No.
Vicki Sorensen?
No.
Skip Daly?
Yes.
Okay, the motion fails by a 3-2 vote.
It's 2 to 3, right?
Huh?
2
I'm sorry, I reversed that 2-3 vote.
I just want to thank you all for participating in this discussion.
Did you want to make a motion, Margaret?
No, I just want to say that I appreciated the discussion and the review.
Okay, we still need to make a motion on and settle this case.
Well, okay, well, I'll make a motion to affirm the administrator's determination in case number ADR-21-3.
I'll second the motion.
Okay.
I'm going to call Larry.
The vote is on petition ADR-21-3, appeal of director's interpretation of existing business use. The motion is to affirm the director's zoning determination. Vote in favor is vote to affirm the determination. Bernie Garitas?
No.
Clemens?
Yes.
Sorensen?
Yes.
Skip Daly?
No.
Mary Beth Smarchek?
Yes.
The vote is approved by the Decision is affirmed by a 3-2 vote of the Board of Zoning Appeals.
I'd like to thank everybody. You know, this was a particularly difficult case for us. Next up, we have, I believe, new business. Yes. Oh, okay. Yes, new business. We have case numbers VAR-21-65A, VAR-21-65B, VAR-21-65C, and Drew's going to tell us more about that.
All right. Hello, everyone. Can you hear me okay?
Yes.
Okay, great. So this is VAR-21-65. It's the Howard minimum lot width variance, Howard side yard setback variance, and the Howard buildable area pole of flag lot variance, all to Chapter 804. It's located at 3330 West Maple Grove Road, and it's located in Richland Township, Section 1. All right, so the petitioner intends to construct 2 post frame structures for agricultural use at the petition site. Both structures intend to utilize existing structural installations that have been present, according to the petitioner, since 2002. The first structure will face north-south and exhibit a 1,360 square foot footprint, and the second structure will face east-west and exhibit 2,688 square feet. The first structure will be approximately 17 feet high, and the second will be approximately 20 feet high. We'll get to the site plan that'll have more details about the structures here in a minute. So the reason for these variances, there's 3 in total. The minimum lot width at building line for the property in Ag RR zoning district is 200 feet. And the required setback for property in the Ag RR district is 50 feet for non-residential structures. Finally, according to Chapter 804-4E regarding buildable area, the pole of a flag lot is classified as non-buildable area. So the petitioner needed to request all 3 of these variances in order to continue on with their improvement location permit review and secure a building permit for the structures. So according to measurements made on Elevate GIS, the pole area of the flag lot measures approximately 177 feet, so under that 200 feet requirement. Additionally, the proposed structures will be located approximately 40 feet from the western property line, and that's a 10-foot encroachment into that required 50 feet setback. And then, of course, any new structures going into non-buildable area, in this case, require a variance approval beforehand. So here we have the location map. You can see the shape here. The pole of the flag lot is this skinny section down here towards the south. And then this larger portion up here to the north is the flag portion. The structures will be placed in this section here. We'll see more detail in the site plan in a moment. Here's the slope map. As you'll note, there are some decent slopes present on the property, especially the farther north you go. And there's also FEMA floodplain on the property as well. If you look towards the south of the map, you'll see some of the structures here and some of the locations where they intend to build the 2 post frame agricultural structures, which would be right about here where the cursor is. Here I have a zoomed in version of the slope map. Again, here's one of the existing agricultural structures, as well as a utility shed. And then this portion of land here that has had some grading done, and there's also a retaining wall along the length here running north-south and then across east-west here. This location is where the petitioner intends to build the 2 post frame agricultural structures. Here we have some site photos. This is just the driveway entrance in these first 2 photographs coming off of what would be West Maple Grove Road. Photographs coming onto the petition site. Here's the driveway coming around, and then another angle of the driveway. You can start to see the existing agricultural structure here in the background. More photographs here. The one on the left shows a location of where the proposed structures will be included. And then on the right-hand side, you have a photograph just continuing up the driveway to the point where you can start to see more detail of the existing structures. And if you continue along the driveway in the back, there is a single-family residence at the end of the driveway. More photographs here of the proposed site for the structures. And then just walking around the property here to get more angles of the proposed site. This one towards the right of your screen is looking back towards Maple Grove Road with the existing structures behind me when I was taking the photograph. Okay, so here we have the consent letter that authorizes Ethan Howard to represent the property owners. And then we also have the letter to the Board of Zoning Appeals here on the screen. It's also included in your packet, and it kind of outlines their intent for the property, a little bit of background history as well. Their measurements, you'll note that are a little bit different than planning staff. This is likely because they likely made these measurements while on foot on the property. And given the topography change across the area where these measurements are made, there is some discrepancy. So we measure based upon what we can use via GIS, and that line obviously is a straight line as the crow would fly. Okay, so here we have some site plan information. The petitioner provided some text first to kind of describe their intent, providing details, existing conditions, existing structures, making a point to state that there are no easements in the buildable area or the building area, as well as providing some measurements for where the structures, the proposed structures, will be located on the property with respect to the property lines. They've also have some text here about setbacks and utilities that you can see on screen, and they're also included in your packet. So here we have the proposed site plan with notes from the petitioner on here. The existing wall running north-south, and then they have the two structures outlined here. The first structure running north-south, 16 feet in width and 80 feet in length. And then farther south, we have the larger structure, 42 feet in width, and then, sorry, the screen's got that covered. Can't read the number, but you can see it on your screen, I'm sure. Just because I can't see it because I'm sharing the screen, the toolbar is covering that location.
64.
Thank you. So yeah, here is the location, proposed locations of the structures, taking advantage of the existing conditions that the petitioner has stated have existed on site for quite some time. And then here's a zoomed out version of what you just saw, showing the proposed locations. All right, so overall, planning staff recommends approval of all three variances. So the first one, VAR-21-65A, which is the minimum lot width. The planning staff is recommending approval, citing that any new development or construction in the accessible buildable area on this property would first require minimum lot width variance given its location. Variance VAR-21-65B, which is the side yard setback variance. Planning staff is recommending approval, citing that any new non-residential development, i.e. agricultural buildings, that utilize the existing structural installations here will require a side yard setback variance. And finally, VAR-21-65C regarding the pole of the flag lot buildable area. Planning staff is also recommending approval, citing that any new development or construction in the accessible buildable area on this property would first require buildable area variance for the pole area of the flag lot. Basically stating that they're using the buildable area that they have on site outside of the pole flag lot requirement, and that getting to any of the other buildable area on the property would be very cumbersome. I will now take any questions.
Does the board have any questions for Drew? Bernie?
Yeah, I think just a couple quick ones. Drew, on the discrepancy for the 192 feet and the maybe 177 that staff measured via GIS, what does the deed say that frontage is? You're muted, Drew.
Thank you. I do have that information. I can pull it up, but I believe it fell in line with approximately what staff had stated.
Okay.
It was closer to 177 than it was 192.
Because that just takes away the question of trying to scale it off or step it off. That's what I was asking. Could you go back to the conditions of approval again? I'm a little slow on the uptake with those.
Yeah, sorry, I didn't mention those in my recommendation, but I do have them. I think
I saw them on the screen.
Yeah, I'm sorry. I'm mixing up with my next petition that actually has conditions of approval. This is just the rationale for approval.
Yeah, it's not actual conditions, Bernie.
Okay.
It's just rationale.
That's what I didn't understand. Thank you very much, Drew. Nice job.
Any additional questions for Drew?
Just state that Bernie, the deed has 185.
Okay. Thank you, Jackie. That tells us that it's less than the 200 feet, doesn't it?
Somewhere in between. Okay. And any additional questions for Drew or staff?
We do have the ability to waive within 10%, but we can't waive it because it doesn't meet the one.
All right. No questions for staff? Okay. Are Larry or Christina Howard here this evening, and would they like to speak?
I believe Ethan Howard is present. And,
Ethan
is the representative.
Okay. Hi, Ethan. Do you swear to tell the truth and nothing but the truth?
Yes, I do.
All right. Please state your name.
My name is Ethan Howard.
Okay. Continue, Ethan.
All right. Thanks for calling on me here. I just wanted to clarify a couple of things related to this variance. As was stated earlier, we just want to build a couple of pole structures out here. We are going to be using existing infrastructure, namely a wall that's already in place. I just wanted to talk about the measurements real quick, just to kind of clarify that. The planner, he is correct. There is large slopes on the property back past the flagpole lot. If you look at the slope map, you can see those towards the north of the flagpole area, making building back there almost impossible. So we are basically confined to this flagpole area. And then talking about the other measurements and stuff, he is correct. I measured those on foot, used a tape measure. The measurement on the west side, that's the one that is 48 feet. That area is pretty flat, so it's pretty close. I would argue that it's pretty close to what I measured it as. And then the other one, that's kind of up in the air. I guess we can go with whatever the council would like as far as the correct measurement for that. Due to the hill there, I measured it as well, but obviously that's not a straight line. But other than that, yeah, I think that's just about it. Thank you for your time and consideration.
Okay, thank you, Mr. Howard. Is there anyone else here that would like to speak on behalf of this petition? I'm sorry, I didn't ask the board if they had any questions for Mr. Howard. Okay, no. All right. Anybody else here that would like to speak on behalf of this petition? Anyone here that wishes to speak against this petition? Seeing none, do one of my board members have a recommended motion, a motion for me?
I can do it.
Okay, thanks, Bernie.
Okay, in the matter of, I'm gonna do all these together. In the matter of VAR-21-65A, VAR-21-65B, VAR-21-65C. This is a Howard minimum lot width to chapter 804, the Howard side yard setback to chapter 804. In the buildable area, parens, pole flag of lot, in parens to chapter 804 respectively, located at 3330 West Maple Grove Road. I move that we approve all three variances based on the findings of fact, staff report, and the petitioner's statements provided to us on this hearing.
I'll second that motion. And call roll, Larry.
Okay, now I'm okay. The vote is on petition VR 21-65A, 65B, and 65C. The Howard minimum lot width variance, chapter 804, the Howard side yard setback variance, chapter 804, and the buildable area variance, chapter 804, respectively. The motion is to approve all three variances based upon the findings. Again, a affirmative vote is a vote to approve all three variances for this property. Bernie Garitas.
Yes.
Clemens.
Yes.
Vicky Sorensen.
Yes.
Daly.
Yes.
Rebecca Smarcheck.
Yes.
The variances are approved by a 5-0 vote.
Everybody, you guys have a good evening. Thank you for coming this evening. Okay, next up we have case number CDU-21-4, conditional use for a general contractor. Drew?
Thank you. All right. Yes, this one is CDU-21-4, Woods conditional use to Chapter 802 for a general contractor. It's located at 4180 North Starnes Road in Richland Township, Section 17. Okay, so this one, petitioner is requesting a conditional use variance for general contractor, which according to Chapter 802 is defined as the following on screen. You can see here in the middle. An individual who contracts to perform building, structure, construction related to related work or to provide supplies on a large scale, or an individual who contracts to erect buildings and or other structures. Construction related work may include, but not limited to, plumbing, landscaping, electrical, framing, concrete, masonry, roofing, etc. So in this case, the petitioner is an electrical contractor and has been operating on site according to their letter since 2006. Also a note, a recent ordinance text amendment, ZOA-21-6, and the corresponding ordinance number approved by the Board of Commissioners 2021-37 was approved in October of this year, and it added general contractor as a conditional use in the rural zones in the zoning ordinance. That would be the Ag-RR district, the FR district, and the CR district, to provide some flexibility for individuals operating, if you will, as rural contractors. Okay, so in Chapter 813 for conditional uses, there are some additional conditions that are applied to specific uses if they qualify for conditional use variance. These are the specific conditions for the rural contractor that was recently approved. And each of them I have in the red text here. A little note that the petitioner and the petition site will either meet the requirement or will be able to meet the requirement through the satisfaction of a condition of approval that I will get to at the end of this presentation. We can come back and refer to this list if we'd like, but I just wanted to provide it in the slideshow. It's also included in your packet, which also has the general conditions that apply to all conditional uses. And those would be able to be met by this petition as well. Here we have the location map. Again, Richland Township. It's on North Starnes Road. Here we have the slope map. Again, we have some FEMA floodplain on the site and some sporadic locations of slopes greater than 15%. We have a single family residence existing on site, as well as the structure that the petitioner is currently operating their electrical contractor use out of. This all started with a submission from the property owner for a residential accessory structure permit. That was back in March of this year. Planning staff during their review stage determined that the Woods Electrical Contractors business was operating out of this property and that there were no prior permits on file. The petitioner was directed to submit a use determination form to planning staff for further review, and planning staff through that determination classified the activity on the site as a general contractor, which at that time was not permitted in this zoning district or listed as a conditional use in this district. General contractor was only permitted in the general business, light industrial, and heavy industrial zones. I already spoke about the ordinance text amendment that came through. There were a few other things that were proposed in that ordinance, but the one item that applies to this case specifically added general contractor as a conditional use in the AgR district, FR district, and CR district. Okay, here we have some site photographs. This is North Starnes Road, the driveway cut leading onto the property. And then just the driveway coming back to the structure where the electrical contracting business is run out of. You know, some cars parked here, another additional accessory structure towards the rear of the, at the end of the driveway. Just turning around and looking again back at the structure for the Woods Electrical Contracting. And then a few photographs of the existing single-family residence. All right, this petition site is a part of a platted subdivision. It's the Francisco Estates subdivision, Tract 3. I just wanted to include this for supplemental information, and we can refer to it if we need. Here we have the letter to the Board of Zoning Appeals. It looks like I misspoke actually in stating that the letter indicated what year the business started running out of the location. I think I located the year 2006 off of the company's website. I think that's where they had stated that they have been on site and been in business since then. Here we have a petitioner submitted site plan. This is the existing site plan. So they have their structure here in question, the 80 by 40 foot structure where the electrical contracting business is run out of. And then here on this next slide, we have the site plan that they submitted to planning staff for the building permit application for the addition that they would like to build on the property, showing that it would be 65 feet from the property line and giving its proposed size. All right, so here we have the recommendation from staff. Planning staff recommends approval of the conditional use request for general contractor based on the findings of fact, subject to the Monroe County Highway Engineer and MS4 coordinator reports with the following conditions. 1, petitioner record an affidavit stating that they will reside full-time on the property while the general contractor use is ongoing. And 2, the petitioner submit a revised site plan showing compliance with condition H for planning staff review and approval. I'll jump back up to condition H just to show you what we're referring to. It's down here at the end, at the bottom of your screen. And it basically is talking about the screening of vehicles and materials for general contracting businesses. If we want to go back to the photographs, we'll note that there is no screening on the south side of the property. And then of course on the north side of the property, there's lots of woodlands. So we don't have to worry about any screening from that direction. But planning staff would like to see a revised site plan that addresses condition H, which primarily talks about screening. I will now take any questions.
Does anyone have any questions for Drew? Don't see any questions from the board for you, Drew. Is Roger and Jennifer Wood, are you here? Roger, Jennifer Woods?
I see Roger, I believe.
Yeah, we're here.
Roger? Yeah, would you like to speak this evening, Roger?
Yes, if we could.
Okay. Do you swear to tell the truth and nothing but the truth?
I do.
All right, state your name for the record.
Roger Woods.
All right, you may proceed, sir.
We are been in electrical contracting business since 2006. And we've just started out with a one-person operation. We've worked our way up to where we have about 20 employees. We originally were in our house at our first location up the road, and then we grown to where we needed an office space. So when we moved here in, I think it was 2010 or 2011, we built the building and we got an office inside the building. And it's me and the wife and our daughter, and I have one full-time estimator that's on site. Our employees typically do not come to the office. They go directly to job sites, construction sites. We have service people that take vehicles home, so they go directly to sites. And like I say, we don't necessarily want everybody here at the office. So that's kind of what we've got going on here. We've got a good thing. We just want to continue it, but we do want to be in compliance with the county. So.
Okay, does the board have any questions for Mr. Woods? Nope, didn't look that way. All right, thank you, Mr. Woods. Is there anyone else here that would like to speak on behalf of this petition? Seeing none, is there anyone here that would like to speak against this petition? Seeing none, does one of my board members have a motion for us?
Could I interrupt real quick and could I actually ask Mr. and Mrs. Woods a quick question?
Sure, Skip.
There were some recommended conditions put on this. Are you comfortable with those?
Where'd they go?
So if I'm understanding correctly, the recommendation is for the screening of the parking area. Is that correct?
That's the way I'm reading it.
Yeah, I feel that's reasonable.
And Mr. Myers, am I missing anything else here? Is there another condition that you've put on here that I might want to get the thoughts on?
The two conditions here that planning staff is requiring are listed on screen. And the affidavit is fairly straightforward. And then of course, the revised site plan, the petitioner can work with planning staff to make sure that they can satisfy that requirement.
And Mr. Woods, you plan on residing full-time in the property, right?
Yeah, this property's been in our family for at least 4 generations. And
okay. Satisfied.
Yeah.
Thanks.
Thank you. Does one of my board members have a motion for us?
I will make a motion.
Okay, go ahead, Skip.
I'm motioning on CDU-21-4 that the planning board approve the variance based on the recommended conditions put upon by the planning department, including the petitioner record an affidavit stating they will reside full-time on the property while the general contractor use is going on. And number 2, that the petitioner submit a revised site plan showing compliance with condition H for planning staff review and approval.
I second.
All right, you want to call the vote, Larry?
Vote is on petition CDU-21-4, Woods Conditional Use to Chapter 802 for general contractor in agricultural zone. Vote in favor is a vote to approve the conditional use with the conditions set forth in the report, staff report, and based upon the findings. Barbara Clemens?
Yes.
Keith Sorensen?
Yes.
Daly?
Yes.
Beth Kismarcha?
Yes.
Garitas?
Yes, I just want to add the comment that this is a perfect example where you can have a general contractor office, neat as a pin, the work done very professionally. The whole family's working in the business, growing it, and it's a thrill to see things like this succeed. So that's it.
Well, Bernie, as you're aware, we changed the ordinance to allow this as a conditional use.
I understand that, and I think that was a great job by staff. I mean that.
I do want to mention is Woods came forward, applied for a building permit for this new structure. That's how we determined there was a business on the site.
Mm-hmm.
You say, looking at that site, you can't tell whether there's a business there, but they were very straightforward that they were operating a business. We worked with them to change the ordinance to allow a conditional use for them and other individuals in a similar circumstance. But it goes to show how difficult it is for us to do enforcement. You know, if people don't apply for permits and just go ahead and do uses in buildings, we have no real way of reviewing what's going on when at an appropriate time. And I just wanted to throw that out because that was not mentioned earlier, but clearly that's one of the factors we run into, that we rely upon people complying with the ordinance and filing for permits. And in this case, they did. And we work with people to have them try to get them in compliance if we can. And the answer is always, if you don't like the ordinance, you need to talk to Margaret and Bernie and have them change the ordinance.
Well, you know, the nice thing about this site, and I'm not going to drag this cat down the road too far, but you know, you look at the conditions of approval and there's not much that has to be done to come into compliance because it's a very professionally run, neat, nice, clean business that it's just a thrill to see it. So that's it.
I agree with Bernie. I just really love that you guys are here and that, you know, that we get to meet you this way, even though it's only virtually.
Thank you.
Thank you.
Announce it was approved.
Okay. Oh, I'm sorry. I the vote, I never announced that it's approved by a 5-0 vote.
That was my fault, Larry. Sorry about that.
Okay, yeah, I wasn't even sure that everybody had voted yet. Okay. It is approved, and you guys have a good evening, Mr. and Mrs. Woods, and keep up the good work.
Thank you.
All right, next up, we have case number CDU-21-5. And this is, Ann's going to tell us more about this.
Thank you, Mary Beth. So the petition site is 3.7 acres located in Richland Township, Section 33. It is currently a parking lot use. So the petitioner is seeking a conditional use approval for off-site parking located in the IG zoning district or general industrial district. This is under Chapter 833, and then for conditional uses under Chapter 813. It states that off-site parking is a conditional use in the IG zone. So the petitioner states that the off-site parking will benefit the adjacent property owner, Catalent Inc. The petitioner will be required to submit an official commercial site plan to the planning department Per the requirements of Chapter 815, should this conditional use request receive approval tonight from the BZA, they have also requested from the BZA 3 design standard variances that would be heard next if approved. The 3 design standard variances are from landscaping, the parking setback, and for performance standards from lighting. So the property is, let's see, oh, let me move this. Okay, so the property is zoned IG. We've seen where it is, and currently the comprehensive plan identifies this area as the Monroe County Urbanizing Area Mixed Use Zone designation. The mixed use zone states that they are the densest, most pedestrian-oriented development types in the urbanizing area. So this is a pictometry photo of the site currently with a site conditions map on the bottom right. So it's been a parking lot since I think what the petitioner stated, possibly from the early 60s. Here are a few current site photos. So the petitioner shows that it's been, a parking lot since 1961 or so. So the property was recently final platted within the Pinnacle Business Park Major Subdivision. It was also formerly known as the ABB Major Subdivision. That would be your Exhibit 4 within the packet. One of the things that they are changing with this proposal is that access to the parking lot will be from the newly constructed Profile Parkway Drive, which is shown in Exhibit 2. The permitted right-of-way permit is Exhibit 3. So striping of the parking lot is depicted here on the right of your screen in Exhibit 1. That's what they're proposing. A good overall view of what the property looks like right now. So currently the parking lot is accessed off Curry Pike. So that will be changed now that the Profile Parkway Drive has been constructed. A driveway will be built to access the parking lot as it exists right now. So some of the conditions for the use of offsite parking is that the facility, sorry, one moment. There we go. That the offsite parking facility is within a reasonable walking distance of said structure or use. So the petitioner, the offsite parking that will be utilized is for the property at 3770 West Jonathan Drive. So they're proposing that people will be shuttled to Catalent. It's the Catalent location that is off of 1100 South Strong Drive. So they are proposing a shuttle, even though it's not within walking distance. Number B is that the parking facility is located in a zoning district where such parking facilities are allowed. So it is a conditional use. Let's see.
And just to clarify on part A, I think part of the off-site parking will be used for the site just on Jonathan, which is within walking distance. But they did say that some of it may be used to shuttle people to a separate location that Catalent also owns. But the primary would be people that would be going to Jonathan, which is just 2 blocks from here.
Thank you, Jackie. Let's see, so C is met and D, that the condition would be modified or terminated. So this requires that there is a written commitment stating that there's a timeline. So that brings me to the staff recommendation, which is that we do recommend approval of the conditional use for offsite parking. And that there does include the following condition, which is that the petitioner record a written commitment stipulating the timeline for the offsite parking and that no other use will occur on the property in conjunction with the offsite parking use. Does anybody have any questions? And Jackie, feel free to interject as you see so.
Does the board have any questions for Ann? Nope, not seeing. Oh, Ernie's got his hand up.
Yeah, and I'm just curious, what is is there still are there still conversations going on with the connectivity over to Sunrise Greetings, or am I to the east?
Yes, Bernie, there are. That's gonna be in a separate petition.
Okay.
But that's gonna be connected.
Okay, thank you.
Okay, any other questions from the board? Okay, is the petitioner here and would they like to speak?
Yes, I'm here. Can you hear me?
Yes, I can. Do you swear to tell the truth and nothing but the truth?
I do.
Please state your name.
My name is Warren Cutshall, and I'm the manager of BB Profile, the entity that's making this petition.
Okay. And go ahead and proceed, sir.
Sure. So this parking lot was not the original intended use for this site. Catalent came to us and said they needed parking for their Jonathan Drive and also Strong Drive. You know, they've had a massive ramp up in need for filling vaccines. We knew we weren't going to be using this parking lot probably for a year. So we said we would try to accommodate them and, you know, put in a driveway, striped it, cut off the access to Curry Pike. My understanding those were some dangerous entrances onto Curry Pike. So those are gone. And thanks to the planning department for their work on this, and appreciate your consideration. Glad to answer any questions you have.
Does the board have any questions for Mr. Cutshall? Nope. Okay, thank you, Mr. Cutshall. Is there anyone else here that would like to speak on behalf of this petition? I believe my dog does. Okay, is there anyone here that would like to speak against this petition? Okay. Would one of my fellow board members be ready with a motion?
I can do it.
Thanks, Bernie.
In the matter of CDU-21-5, this is the BB Profile Offsite Parking Conditional Use. I move that we approve the conditional use for the offsite parking of Chapter 802 and 813 based on the findings of fact, subject to the Monroe County Highway and Drainage Engineer reports, with the following condition: that 1, the petitioner record a written commitment stipulating the timeline for the offsite parking, and that no other use will occur on the property in conjunction with offsite parking use. I make this motion based on findings of fact in the staff report.
Second.
I'll second.
Oh, okay.
I just want to make one correction. It is a conditional use from offsite parking of Chapter 833, which is the old 2 mile fringe, not 802. So that I think other than is the same.
So amended.
Okay, I'll call the roll. The motion is approved to approve CDU-21-5 BB Profile Offsite Parking Conditional Use from Chapter 833 and 813. A affirmative vote is a vote to approve the conditional use with the conditions set forth in the staff recommendation, that a written commitment stipulating a timeline be set forth, and that no other use occur on the property in conjunction with the offsite parking use. Again, Vicky Sorensen.
Yes.
Daly.
Yes.
Jessica Smarchek.
Yes.
Toss.
Yes.
Margaret Clemens.
Yes.
The conditional use is approved by a 5-0 vote.
Thank you, Mr. Cutshall. You have a wonderful evening. Next up, we have case numbers VAR-21-67A, VAR-21-67B, VAR-21-67C. And it looks like Anne's going to tell us about this one as well.
Thank you. So this is for the same site. Now that you have approved the conditional use, there are 3 requirements that they are requesting variances from. So the first one would be the landscaping, which is buffer yard, interior, and perimeter from chapter 830. So the site would be required to install landscaping. The lot is currently paved, so they would be required to install buffer yards and perimeter landscaping. The site is currently contaminated with PCB and soil disturbance is prohibited. The second variance request is from the parking setback from right-of-way. So setback from right-of-way from chapter 806. So the setback requires that a minimum of 10 feet is required from a right-of-way for parking areas. And currently the existing parking lot encroaches into the dedicated right-of-way. There is an illustration to the right. So, there we go. So some of the parking lot does encroach into the right-of-way. That is something that will be, the petitioners are proposing a preliminary plat amendment to fix this correction. But for now, there's a request for that from that setback of 10 feet. And then the third requirement, which is from the performance standards of lighting, which is that the petitioners are proposing to install lighting on the property, but the chapter 802-4, so it limits lighting to not to exceed 1 foot candle at the property line. So currently the petitioners intends to install lighting that is most likely going to, because of the proximity to North Curry Pike, would be unable to meet that 1 foot candle at property boundary. So same petitioner letter that you've seen. So the staff recommendation is approval on all 3 variance requests in accordance with the highway engineer and MS4 coordinator reports with following condition that future permanent lighting proposed on the site shall comply with the performance standards. So if the site were to, we expect that this use is temporary, but if for some reason it was not temporary, we do expect the use should be able to comply with the lighting standards for permanent parking lot use. Does anybody have any questions?
Any questions for Ann? Oh, Bernie?
Yeah, I'm sorry, just a quick observation. My hunch would be that the reason why the setback for the parking not meet the current code is because Curry Pike was widened several years ago, and that parking lot was existing and probably met the criteria. I don't know that, but there were right-of-way takes and conveyances to the state and for Curry Pike expansion. So that's something that's certainly not due to actions by the petitioner, in my judgment. So that's it. Thanks.
Any further questions for staff? Mr. Cutshaw, I guess we weren't quite done with you yet. You're still under oath, and would you like to speak?
Sure. Thanks again, Anne, for the presentation. I guess going along the 3 different variances, the landscape issue, we do have a recorded restrictive covenant. That parking lot is intended to remain a parking lot and to not, dig up the cap that's on it. So that's the first request for variance, the reasoning for that. Like Bernie said, the right of way was taken, but my understanding is the county wants to undo that, and we'd be glad to do that. There's a fence that's been there existing for 60 years. Spoke to the highway department, and I don't think they have any intention of widening Curry, especially not into our parking lot. And then the lighting plan, we're glad to comply with whatever standards are requested. Thanks for your consideration, and glad to answer any questions you might have.
Does the board have any questions for Mr. Cutshaw? Nope. Okay. And is there anyone here that would like to speak on behalf of this petition? Seeing none, is there anyone here from the public that would like to speak against this petition? Seeing none, does one of my fellow board members have a motion ready?
Go ahead, Vicky. No, you're on. You're on, Vicky.
I'll make a motion. With regard to case number VAR-21-67A, landscaping buffered yard interior perimeter to chapter 830, VA-21-67B, parking setback from right of way to chapter 806, VA-21-67C, performance standards lighting to chapter 802-4. I move to approve all three variances request in accordance with the highway engineer and MS4 coordinator reports with the following condition. Future permanent lighting proposed on the site shall comply with performance standards.
Second.
I'll second. Okay.
I'll call the roll. The motion is on to approve all three variances, 2167A, B, and C, the landscaping and lighting variances for the subject property. The recommended motions is in accordance with staff reports and with the condition that future permanent lighting proposed on the site comply with performance standards. Again, the motion is to approve all three variances subject to the staff recommendations and the condition in regard to lighting. Skip Daly?
Yes.
Rebecca Smarchak?
Yes.
Veritas?
Yes.
Margaret Clemens?
Yes.
Sorensen?
Yes.
Three variances are approved by a 5-0 vote.
All right. Thank you, everybody. Do we have a motion to adjourn the meeting as there are no reports to be read or anything?
So two quick reports, Mary Beth. One is planners Rebecca Payne. Her last day is this Friday, December 3rd. She's going to be leaving to pursue her full-time master's degree at IU in the public health school. So we're wishing her the best and just wanted to let you know that she'll be leaving us shortly.
We will miss you, Rebecca, and we will definitely wish you the best.
I want to say this is the last meeting of the year. It always seems like they go quickly. In some ways they go quickly, some ways they go. But again, it's December. This is the last meeting of the year. I want to thank you all for your service to the BZA. You've been very professional. You carefully listen to the cases. You bring out things that neither staff nor the petitioners nor the remonstrators have thought of. And again, we appreciate your thoughtfulness and your service to the community. This is not an easy job. And again, thank you. One other thing I do want to say is it's Dave Schilling's birthday, and he's basically at a BZA meeting. So I don't think we should sing happy birthday to them. I don't think I want to hear that, but we should wish Dave a happy birthday.
Happy birthday, Dave.
Happy birthday.
Thank you very much. I do have a report, and I hate to follow up on Larry's statement that this is the last meeting of the year by requesting you to have a special meeting, maybe at the middle of the month. There's been a petition for judicial review of the Bedford recycling case. And so I think it would be a good idea to meet in an executive session and discuss some of the strategies with respect to that litigation, and then to approve written findings in support of your decision. So if it's possible, maybe at the middle of the month to schedule a meeting, that would be great. And I don't know.
For me, it would have to be 6 o'clock or later in the evening to do that.
Yeah.
And
Okay.
I'm gonna interrupt for a moment. I apologize. Please shoot an email out about any of those proposed dates. I'd love to. I have a hard stop at 8 o'clock for the holiday that I need to go observe with my daughter. So thank you, and I'm going to bow out.
See you, Skip.
Good night, Skip.
Monica.
Well, so I don't know, Jackie, do you want to send out a poll, or just to have people email dates in, or?
Yeah, I can start with a doodle poll, or people can respond with just dates of preference. So, yep.
We can do it on Christmas, Mr. Grinch.
Let's not do that.
Uh-oh. All right. Well, that would be it then, and I thank you for that.
You have a happy birthday, Dave, and
thanks.
Happy holidays to the staff and all the rest of the board.
Okay,
I hope you enjoy your holiday.
I have a quick question. This is Bernie again. You know, I look at some of these petitions that we have variances on, and this last one was a good example. I can think of a couple different properties that I've worked on over the years where there's been public dedication of right-of-way for public improvements, where buildings and structures and things have become non-conforming with the ordinances because of the public purchase of right-of-way specifically. And no action now. I just wanted to bring that point up and wonder if there's a way to take people off the hook, or property off the hook, if they have to do something later. Then they go through the expense of variances and different planning operations, and they ended up selling or conveying property for public good, and then they've got to go back and do variances. So that's all I've got. Happy birthday, Dave.
Yeah, thank you.
Yeah.
Hey, yeah, I would say, Bernie, that sometimes that those people are paid for the damages to their property, and then they come back and get a variance, so it's just kind of double dipping. So that does happen.
Well, I'm a double dipper from way back, so anyway. All right, thanks, appreciate it.
All right.
All right, I move that we adjourn this meeting and that everybody have a wonderful holiday.
Thank you, and happy birthday.
Thanks.
Bye.
Bye.